its computer. Okay, so welcome everybody. This is my first in a new series called Conversations, and today I have the privilege of talking to a good friend and colleague, David Law. David, I wonder if you can just really briefly tell me what your educational qualifications are.
Well, the ones that are relevant to what we're talking about is that I'm qualified social worker and have been since 1982, although I've been involved in social work since 1975. I'm also a qualified lawyer from Dundee, and I guess they're the main qualifications which I would attempt to bring together in thinking about the relationship between law and social work.
Great, thanks for that, David. And just like again, in sort of a brief summary, what has been your work history over the years?
I've worked both in England and Scotland, and for a period in Ireland, mainly with children and families. My work in England was predominantly, to begin with, in residential care with children, and then later in probation and juvenile justice, working with the courts. I was court officer. I ran a project for aiming to keep young people out of care and custody with some degree of success. I was childcare training officer then when I moved to Scotland, and then worked in Dundee University lecturing through the 80s and 90s on the Certificate in Child Protection, and co-wrote the materials for that with Kathleen Marshall. Later, after qualifying as a lawyer, I taught, as you know, at Dundee, social work, law and policy, both to undergraduates and to postgraduates. And more recently, I've taught at Stirling University with undergraduates, and again, law and social policy. And my most recent work has been with a school in Perth that's been cited in the Scottish Child Abuse Inquiry, working as an expert consultant.
Great, thanks. I feel like I'm asking you questions to identify your expertise as an expert witness at trial, but and the students will see a little bit of that. Just really those questions to give you a sense of your background, but also your I guess your credibility in the conversations that we're having now. And I should actually have said at the start to folks that are watching that both of us are talking in an individual capacity, so we're not representing any organisations, so the usual disclaimers apply. So I guess you know, we increasingly, I mean, different professionals, I guess, have always worked together. I mean, you can't work in a silo or within a kind of vacuum, and so in some ways interprofessionalism is not a new thing, but I guess what is new is an emphasis that it has been on encouraging and supporting interprofessionalism, and in fact that it's no longer okay to work within your own in a little individual isolated circle. So I think what I would like to talk to you today is about I guess the training and the mindset of people who are working in the legal profession. And I'm saying legal profession broadly understood, because obviously there are various forms of lawyers, and there are you know, people who work in legal services, etc. I mean, each discipline has its own different language and focus and emphasis. And I'm thinking, if you could, David, cast your mind back to many years ago when you were somewhat younger, as a law student, what kinds of, can you think about what sort of mindset as part of, I guess, being trained in lawyering and the art of lawyering was encouraged?
I did my degree at Dundee, and a major part and major emphasis of the training at Dundee and the development of the law course there is the concept of social justice, that law should be not just about helping to determine an act of parliament or representing a client in court, but that should be underpinned by concepts of social justice. In other words, that the law has a purpose for the good of the people and for the protection of society, and not necessarily separating those two things out. I think that's fairly true of most law courses. Some law courses across the UK and elsewhere will tend to focus on more aspects of commercial law and commercial practice. And even within that, there's still a need for social justice, because it should be about promoting ethical practice. And social workers and lawyers are both held to codes of conduct.
Right, right. And I just wanted to push you a little bit further on that, because I mean, there definitely is. I mean, I've taught in law schools, different law schools, and obviously, law, depending on the law school, they have a different, different points of emphasis and priorities, and I guess a signature experience for law students. But there definitely, certainly from my perspective, has a little bit of a different mindset, particularly in more traditional law schools that might focus, for example, on more kind of doctrinal, sometimes that's called black letter law, where, the skills that you're developing as a student and then obviously later as a law practitioner is focusing on, I guess, what we would call technicism, the kind of being able to very sharply and clearly deal with rules, and I guess cutting through sometimes the more kind of complex and confusing and emotional realities that human beings bring to the experience. So I'm just I'd be interested, because that's quite a very different approach in some ways than social work training. Again, recognising that social work training is very varied as well. Yep. But and I will say, this is more of a comment to add to what I've just said, is I think sometimes social work students, when they first come across topics related to the law, is they can almost be seduced by that technicism. Let's find the rule or the regulation in this place, and kind of trying to attempt to apply it in a black and white way. So I'm just wondering if you can talk about some of the kind of sharpening of skills. I mean, what are the kind of skills that lawyers actually need to be good lawyers?
I would say a fundamental skill is an ability to do good research. And in the respect of lawyers, that's good legal research. Traditionally, anybody doing a law degree could have to remember something like 4,000 different cases, particularly with Scots law or English law, which is very heavily dominated by case law. These days, access to that material is much easier. That can be found online, so long as you check your sources are accurate and reliable. But for a good lawyer, they have to know how the law works. They have to know the relationship between law and practice, be it to do with criminal law, be it to do with commercial law. It's about knowing the framework, about the role of law in society, and then knowing where to find the information, and then importantly, how to interpret that information. So what a lawyer or any good law teacher would tell you is important, for example, of being able to understand the importance of ands or if or qualifications in the statutes, and the respective roles of powers and duties. Now, what I would say, which is perhaps broader than the question you're asking, is that historically, I think law has very much more been about the black letter law. And I think what's changed in more recent years, which has brought it closer to the social justice, and this was reflected in my training, is a heavy emphasis on human rights, the role of the European Court of Human Rights, the UN Convention on Human Rights, and lawyers in particular have to be very careful when they're practicing to respect those human rights, and that brings it closer to the concepts of social justice. The social workers will be familiar with. Social workers, on the other hand, have traditionally relied on the lawyers and the solicitors doing the work in court, and that's particularly true south of the border in terms of children's cases, because it's still a family court system. The social worker within the court is providing information and opinion, expert opinion quite often, about a child's needs or a family's needs it's the role of the lawyer to take that and to use that as part of their argument in favour of their client.
Right.
Or if they're on the opposing side, to challenge that.
Right, and that's true. But I'm thinking also, you know, there is a particular kind of approach to training, even in more progressive law schools that, as you say, get away from that doctrinal thing. You still need to, I guess there's two issues I'm thinking of. One is, for example, if you're looking at, let's just say, you know, whether your client or the person that you're working with is going to be charged with assault. Like, you need to be able, there are particular tests, you know, the old thing that you learn in the law textbooks about, you know, what the key elements are for assault. And so you kind of, you learn to go through the satisfying those tests and what are the various prongs. So that's a very different way of thinking. And I'm also thinking about, and you know, we did this recently with the students because we had a discussion about the idea of a rule of law, and all the complexity that was in, and the idea of what is a good law. And we looked at Joseph Rast's idea about what his idea of a good law is. That's probably going back a few years for you now. But I guess one of the things that we talked about, and we use the example, and it's often used, that the laws in Nazi Germany, you know, from a moral or ethical perspective, may have seen to be quite repugnant. That's what Nuremberg was about. You know, that they might have been seen as morally and ethically repugnant, and you know, most good-minded people would not disagree with that. But however, there certainly was a strong argument that actually, in terms of you know, the various schools that say, well, is it a good law? Does it meet the kind of standards for the construction of laws? In fact, it was very much in keeping. Now, without getting beyond the kind of parameters of this discussion, what we can say is that certainly that after that event, that kind of put the cat among the pigeons amongst jurisprudential scholars, because it kind of raised an issue. How could you say that, you know, this morally repugnant regime, you know, on one hand, you know, is really kind of ethically bankrupt and goes against what we now understand to be international norms, but at the same time, in terms of a legal system, meets those requirements. Now, why I've taken a real long bow here is, I guess, some of the kind of disputes that happen sometimes between social workers and lawyers are around the idea of law in context. The lawyer may be more concerned with you know, assisting on using a statute or applying case law in approach to an issue, and following that out, and kind of maybe not factoring in or associating context in the way in which a social worker would.
I think that is best demonstrated when you're looking at social workers needing to bring matters before the court. For example, in a dispute over contact and residence for a child, you may have a situation where the lawyer, solicitor, and the court, their role is to interpret, for example, Section 1 and Section 2 of the Children of Scotland Act, which says who has parental rights and responsibilities. If somebody is wanting to remove or to interfere with those rights and responsibilities because of a child being harmed, the social worker has got to provide the context to that. But the role of the court is deciding the application of the law. That doesn't mean to say that the law is always black letter law. The law is open to interpretation. And probably an excellent example of that, which I think anybody watching this in the next 12 months will understand, is what's just happened in the Supreme Court. You have the Scottish Court of Session ruling one way, the highest court in England beyond or outside of the Supreme Court ruling a different way, and then the Supreme Court effectively supporting the Scottish interpretation. And that hits at the heart, I think, of the relationship between the state the judiciary, the legislature, and government, which is reflected in some ways in the differences between social work practice and legal practice.
Yeah.
What the court was deciding is what is the core law. Contrary to what the press would have you believe, the court was very clear. For example, they weren't deciding on the rights or wrongs of the situation in terms of Brexit. They were deciding and making a statement of law and saying that in their finding that the government had breached the law. As Lady Hale was very clear saying, that doesn't mean to say that the purpose of what Boris Johnson was trying to do in terms of leaving the EU was right or wrong. The way he was going about it was wrong.
Yeah, and I think you've raised a really important issue here, because I think this is where, different professions might use different words or have a different priority in terms of their interprofessional communication, because the notion of rights and wrongs, which is a great phrase to use, I mean, certainly in terms of social work education, that's pretty much part of the kind of day-to-day practice experience and the training nuances. I mean, there's a morality and an ethics that kind of underpins the social work profession. In law, of course, there is also an ethic. I would say an ethical system. There's clear codes of practice, and and there's obviously practice guidelines depending on which jurisdiction that you're in. But sometimes decisions can come, courts can make decisions which are legally correct, inverted commas, because it's always moving and subject to interpretation, as you said, but in fact may not seem to be politically or ethically correct. And I think, courts have been making it quite clear about where there's judge-made law and where courts believe that it's better. It's a public policy issue. It's a public interest issue, and it's better for the Parliament to comment on that. And speaking about other decisions, this must be the month of decisions, because there was also a recent decision in the High Court in England regarding a transgender man who had a child, about whether he could be recognised as the father on English birth certificates. I don't know whether you've seen that judgment yet. It's definitely worthwhile reading, that's for sure. And the court, the court came out with an interesting decision, and we'll leave that for another conversation, because it could be also about unintended consequences of decisions. But basically, it decided that that the only individual who could give birth to a child would be a mother, and that would be on the birth certificate. And but what they did is actually the definition of mother now is more broad than mothers as we would normally understood, but can include men who are mothers as well. So that raises a whole lot of other issues. But I guess what I'm saying is, in that decision, that made it quite clear that there were other kind of public policy issues, for example, about whether trans men should get access to IVF, etc., where the courts have to tread that fine line, don't they, between interpreting the law, the statutes as they were written, the case law that's maybe emerged as part of those statutes, but it can't go really much further than it's contained, isn't it?
Yes. I think what's important about that is also recognising that quite often the law is quiet in certain areas. And quite often social workers think there should be a law for this or there should be a law for that. And they come in and they're a bit frightened by social work training when they're studying law, because they think there's too much to learn. But at the same time, they're quite excited because they think it'll give them all the answers. And the reality is that the law doesn't give all of the answers. And a good example of that is when you look at the law as a living instrument. When I've been working on the inquiry for the child abuse inquiry, what's interesting is to note that 30 years ago, for example, there were no necessary checks on people working with children. There were superficial checks, but pretty well anybody could do so. Now, it's interesting because it's important, I think, also for social workers to realise where the law comes from, is having seen situations develop where children haven't been protected and the various inquiries where children haven't been protected, be they in residential care or the likes of the Mary Caldwell inquiry in 1964, has prompted social workers and politicians to work together to see a change in the law, which then provides better protection. And a really good example of that was the response to the Dunblane inquiry, which shifted an emphasis in the law from people being able to work with children and the employer having to prove that there was something wrong with them to stop them working. In other words, have they got a criminal conviction? To now the onus being on the person applying to work with children to have to prove that they are a fit and proper person. So the law has developed, and we now have a regime in the law which social workers have to operate within and are part of, which is about protecting children better within the community.
Well, having said what you said, you've opened up another interesting issue about interprofessionalism, because, you know, as you said, that law is a living tradition, and so is social work. Actually, I mean, social work has very much changed the way it's approached. It's had to kind of do some navel gazing about, you know, why does it exist? How does it differ from other professions? And I'm just wondering, I mean, you talked about, you know, before about, you know, social workers providing reports and expertise, and then the lawyers come in and kind of, I mean, I'm paraphrasing it, but basically come in and look at the kind of, you know, interpretation of the legislation and its application. But I'm wondering if we can step back from that in the sense of, do you think that there will be possible space within that interprofessionalism for, you know, lawyers and social workers and other professionals indeed to sit down around a table and strategize? So, for example, you know, particularly where there is, you know, a situation where, you know, someone has to appear before the courts, or indeed a hearing of some sort. The lawyers often have to develop a core case theory to work out how they're going to run the case. I think particularly, I mean, we often think about child protection, but there's another whole area of social work law, which is criminal justice law, which is about, you know, young offenders. And unfortunately, sometimes people forget that that's the whole area of social work. So sometimes you kind of, you know, you have to run sentencing pleas to kind of hopefully, you know, get the sentence that you think that your client, and when I say your client, the lawyers, but also the social work team that's working in support of them, hopefully to get the best deal. Do you think with that interprofessionalism there will come a time where, you know, the various groups sit around and strategize? And I'm not just talking about, David, in terms of the immediate case. It might be, for example, particularly around advocacy and law reform, areas where we know there are gaps. And I mean, one of the examples again that I've used with my students to say how law can be used creatively and unexpectedly to deal with social issues. And I use the example in Australia and Canada, where the concept of fiduciary duty, which comes under the company laws regime, which is really to do with, you know, the special responsibility that directors have in companies, how that in both those jurisdictions, quite independently of each other, although I'm sure lots of emails were exchanged, where that kind of legal concept that was used in a very different area of law. I mean, you wouldn't even think about, hello, company law, what's that got to do with what we're dealing with? But how that's being used, for example, to take the state or a government department, you know, to the courts when, you know, children who've been living in care homes or in government institutions have been abused. And, you know, basically that creative area of jurisprudence has been used to, I guess, create new legal rights, and, well, not new legal rights, but certainly another way of covering, you know, getting some change happening and providing some redress for victims of abuse in state institutions. Now, as I said, that can only take place by different interprofessional strategizing, like if we're not going to get any change in this particular area. Now, I'm not expecting you to be an expert on any of this sort of stuff, but whether you have any thoughts about, like, because people get to know where the gaps are.
I think some of it's about the labels you give to different things. You're talking about fiduciary duties. what a lot of law relating to social work already includes are principles of practice. So, for example, and this applies to the legal profession and to the courts as much as it does to children, is that decisions have got to be made in the best interest of the child, both now and throughout their childhood. Now, that coming into the 95 Act in Scotland was a significant change because prior to that, the law tended to set out what was an offence against a child, the consequence of that offence, the role of the social work through the Social Work Scotland Act, for example, what their powers and duties were. It's only in more recent times that principles have been applied. And it's also interesting, one of the things I discovered, which I'd have to say surprised me a little, was how recent the whole concept of policy in relation to law is. If you go back 20 years, both the English and Scottish governments were producing very little in the way of policy. You've now got things like GERFEC in Scotland, which underpin legislation which is embedded in law, and it's a set of principles about how to work with children and young people. And as I say, those principles apply to everybody within it. And I think in terms of actually sitting down and strategizing, that has been happening for quite a long time. For example, when I chaired case conferences in Falkirk and Stirling, we would regularly have both the local authority solicitor present, and if the parent or the child wanted to bring a representative, allow them to come. Now, there's always the danger of that becoming a bit adversarial, but the primary purpose was about saying, what are our concerns? How do we address these concerns? What are the risks? How do we reduce these risks? What does the law allow us to do? Now, one of the bits I think is of crucial importance in social work practice, which a lawyer would take for granted, is evidence-based practice. I've seen so many situations where young people have been received into care, and the risk has been very clear at the time, but there's little evidence that that's an ongoing risk. And of course, once a child is away from home, they're not at risk, so you're not collecting further evidence. So a year or two down the line, when you're deciding, well, actually, it's not appropriate for this young person to go home and go back and live with the parents, you're then having to say, well, okay, where's the evidence for that? And there, even in Scotland, you're into a much stronger legal position. So social work is from day one in intervening in families. And I'm talking about child protection now, but it applies in every area of practice. It applies working with the elderly or the mental health issues. Is about social workers developing evidence-based practice.
I totally agree, and I think that is one of the differences in training, and hopefully social work training is changing. I mean, I'm thinking back, and it's been, like a long time ago since I studied law, but I can remember, certainly in, when you're doing criminal law, for example, the importance of establishing things like the chain of causation and all that sort of stuff. And I think, the cases, for example, where, something has gone terribly wrong with local authorities, it's often been where, facts not just have not been recorded, but in fact the evidence base of the facts haven't been tested. So I think you're absolutely right, and the more that we can, I think that's one thing that law can help contribute to social work education is, some of the work around the kind of standards of evidence, not just in terms of like the differences there, but how we understand the idea of evidence, and how even the difference, for example, between hearsay. I mean, that's something that's sometimes not necessarily articulated in the best way within social work education, case note writing, all that sort of thing. I'm just wanting to draw this to a close, just one final question, and it's probably a bit of a tricky one, or a bit of a naughty one in some ways. What in terms of social workers working with lawyers, what sort of things do you think that they should take into account, or the sort of questions they should ask, or understand the difference of perspective? Because I think sometimes, as I said, that's where the kind of confusions can be that maybe one's interest or preoccupations, depending on one's profession, might be a bit different?
I think the starting point is social workers already are required to share responsibility, to work in partnership with other agencies. Now, that's not, the danger is the social worker then sees the other agencies as their agents, them collecting together the information that they take forward. When in actual fact, all of those agencies, and the reason I'm making this point is because the legal profession can be seen as one of those agencies if social workers are open to that and understand their role. It's a team working together, collecting information. It's a team working together for the best interest of either the young person or the adult or the person who is charged with an offence, to get a solution that's going to be in everybody's best interest. And to avoid going back into examples from childcare, an example which you'll be familiar with because we've used it in the training with social workers, is how you go about dealing with somebody who's who exercise domestic violence against a partner. An easy solution to that is to say you exclude them, you protect the individual who's the victim. What the social worker needs to do, and which a lawyer can help them with, and the law can help them with, is to say, well, okay, there are different alternatives. The example which we've used in practice in terms of scenario is where this individual who's perpetrating the abuse still got a relationship with his children. Children might be at risk, but he's also the breadwinner within the family, maybe living with elderly parents who also have to be cared for. And it's recognizing that, it's a bit like a bubble when you intervene in a family. What you do for one person may have a knock-on effect for what happens. So what a lawyer and a social worker can do together, and this is where social workers understanding the role of the law, is to say, well, okay, the easy ABC black letter solution is this guy has committed an offence, take him to court, you get him sent to prison for assault or domestic violence. The alternative might be to say, well, okay, the law also allows for a community payback order where you can work with that individual on his violent behaviour, on his offending behaviour, and maybe within that, reduce the risks to a level that enables him to continue playing a significant part in the family. And then your objective is about keeping the family together, but it's using the law and taking the advice from the legal profession as to how you use the law to get the best solution, if that makes sense.
Yeah, it certainly does. Well, look, David, I think we might wrap that up. Thanks for the opportunity to discuss this with you today. I know I'll be getting you back for other conversations around the law. So, as I said, it was a pleasure just to talk about those issues about working with lawyers, because I think you've been on both sides of the process and on other sides as well, and other kind of, I shouldn't say sides, but I think there are different realities. And in fact, and it's not so unusual. There's actually lots of social workers who end up becoming lawyers, and there's lots of lawyers who end up doing social work. I mean, it's not a antithetical relationship at all, is it?
No, it's not. And it's maybe relevant to point out that my interest in law developed from working in a situation I said before about working with young people at risk of care or custody. And what I rapidly learned doing that job was that having an understanding of the law and being able to argue and present a case from a social work perspective that was evidence-based, and where I could quote legislation, I could actually use that as a mechanism, and this was in England, for keeping young people out of custody. And as a result, managed to reduce, in Maidenhead and Windsor, which is a, dare I say, magistrates are preferred custody quite often, to reduce it to a zero custody rate.
That's brilliant.
That was a really good example of social work and lawyers working together.
Well, thank you very much for that, David.
Thank you.